Dear viewers, in the last session we discussed about Memorandum of Association and Articles of Association and binding force of Memorandum and Articles of Association. In this session we are going to discuss Prospectus and rules relating to issue of prospectus to the general public. The objectives of the lesson are to explain the kinds of prospectus, rules relating to issue of prospectus, C. SEBI's control over the company in issuing prospectus to the public. Already we discussed that a private company must not issue prospectus to the general public to raise funds for company, but a public company can issue prospectus to raise company's capital. Prospectus is defined by section 2 subsection 70 of the Act in the following words. It means any document described or issued as a prospectus and includes a red herring prospectus referred to in section 32 or shelf prospectus referred to in section 31 or any notice, circular, advertisement or other document inviting offers from the public for subscription or purchase of any securities of a body corporate. An abridged prospectus means a memorandum containing such salient features of a prospectus as may be specified by SEBI by making regulations, section 2 subsection 1 of the Act. Section 33, application forms. Application forms for securities cannot be issued unless they are accompanied by a memorandum containing such salient features of a prospectus as may be prescribed. This is known as abridged prospectus. The full prospectus has to be maintained in the office of the company. A prospectus in respect of which the securities or class of securities included therein are issued for subscription in one or more issues over a certain period without issue of a further prospectus. Section 31, explanation. A red herring prospectus means a prospectus which does not include complete particulars of the quantum or price of the securities included therein. Section 32, explanation. Information memorandum means a company filing a shelf prospectus is required to file an information memorandum containing all the material facts relating to new charges created, changes in the financial position of the company occurring since the first offer of securities or between the preceding offer and the succeeding offer. Other particulars may also be prescribed. Filing has to be done with the ROC within the prescribed time prior to the issue of second or subsequent offer of securities under the shelf prospectus. Section 31, subsection 2. Where a company intends to issue a public appeal for subscription of its shares or debentures, it is essential for it to issue a prospectus. Section 25 of the Act requires that no application for shares or debentures of a company can be invited unless the appeal is accompanied with a prospectus. According to section 23, subsection 1 of the Act, a public company may issue securities A to public through prospectus, herein referred to as public offer, by complying with the provisions of this part, B through private placement by complying with the provisions of part 2 of this chapter, or C through rights issue or bonus issue in accordance with the provisions of this Act, and in case of a listed company, or A company which intends to get its securities listed also with the provisions of SEBI, rules and regulations made thereunder. According to section 23, subsection 2 of the Act, a private company may issue securities by way of rights issue or bonus issue in accordance with the provisions of this Act, or through private placement by complying with the provisions of Part 2 of this chapter. Explanation: for the purpose of this chapter, public offer includes initial public offer or further public offer of securities to the public by a company, or an offer for sale of securities to the public by an existing shareholder through issue of prospectus. Section 24. Powers of SEBI to regulate issue and transfer of securities. 1. The provisions contained in this chapter 4 and in section 127 shall a. insofar as they relate to 1. issue and transfer of securities, and 2. non-payment of dividend by listed companies which intend to get their securities listed on any recognized exchange in India, except as provided under this Act, be administered by SEBI by making regulations in this behalf. B. In any other case, be administered by the central government. Section 25. Documents containing offer of securities for sale to be deemed as prospectus. Where a company allots or agrees to allot any securities of the company by offering for sale to the public, any document by which offer for sale to the public is made shall, for all purposes, be deemed to be a prospectus issued by the company, and all enactments and rules of law as to the contents of prospectus and as to liability in respect of misstatements in and omission from prospectus or otherwise relating to prospectus shall apply with modification as specified in subsection 3 and 4, and shall have effect accordingly as if the securities had been offered to the public for subscription. Contents of prospectus. Section 26 of the Act casts a statutory duty upon the company to disclose matters specified in Part 1 of Chapter 3, and for private placement compliance with the provisions of Part 2 of Companies Act 2013 is required. Private placement means any offer of securities or invitation to subscribe securities to select group of persons by a company other than by way of public offer through issue of a private placement offer letter, and which satisfies the conditions specified in the respective clause. Section 26 of the Act requires that if the prospectus includes a statement purporting to be made by an expert, his consent in writing should be obtained and this fact be stated in the prospectus. It should also state that the consent has not been withdrawn. The term expert has been defined in section 2 subsection 38 of the Act and includes an engineer, a valuer, an accountant, and any other person whose profession gives an authority to a statement made by him. The expert should not be one who is himself engaged or interested in the formation, promotion, or management of the company. In other words, he should be unconnected with the formation or management of the company. According to section 26 subsection 8 of the Act, the prospectus must contain a statement that a copy has been delivered for registration, indicating the requisite documents delivered therewith. According to section 26 subsection 1 of the Act, every prospectus must be dated. It must be issued within 90 days of its registration, either by newspaper advertisement or otherwise. The prospectus should contain all the information which is required to be disclosed in the section 26 of the Companies Act 2013. Lord Kindersley, a New Brunswick Company versus Muggeridge, 1860, Law Times, page 651, observed that prospectus is one of the means by which the investor is informed about the soundness of the company's venture. That being the basic purpose of the prospectus, the law, through a comprehensive set of regulations, seeks to protect the investors by ensuring that the fullest disclosures of all material facts and essential particulars are made by the company in its prospectus, so that the public can assess its credibility and financial soundness. The matters as specified in Schedule 2, Part 1 and the report stated in Part 2 of the Companies Act are to be stated in the prospectus. In Pramadnath Sanyal versus Kali Kumar Dutt, AER 1925, Calcutta, page 714, the company inserted an advertisement in newspaper stating some shares are still available for sale according to the terms of the prospectus of the company, which can be obtained on application. It was held that the advertisement constituted a prospectus as it invited the public to purchase shares. The directors were therefore penalized for not complying with requirements of filing a copy thereof with the ROC under section 27 subsection 9 of the Companies Act 2013. A document to be a prospectus must be issued to the public, and provisions of the Act are not attracted unless the prospectus is issued to the public. In Nash versus Lind, 1929, appeal cases, page 158, make this point further clear. In this case, several copies of a document marked strictly confidential and containing particulars of a proposed issue of shares were sent accompanied by application form by the managing director of the company to co-director, who sent a copy to a solicitor, who in turn gave to a client who passed it on to a relation. Thus, the document passed privately through a small group of friends of the directors. The House of Lords ruled that there had been no issue to the public and therefore no action for compensation of loss caused to the allottees would sustain. The word public means public at large, that is, any section of the public. It need not be necessarily made to the public as a whole. In Re South of England Natural Gas and Petroleum Company Limited, 1911, 1 Chancery, 573, 3000 copies of a document in the form of a prospectus were sent out and distributed among the members of certain gas companies only. It was held that it was a prospectus issued to the public. Section 42 of the Companies Act 2013 makes it clear that the term public includes any section of the public, whether selected as members or debenture holders of the company concerned. Liability for omission or fraudulent misstatement in prospectus. According to section 26, subsection 8 of the Act, any omission from a prospectus of those matters which are required to be stated as per section 26 of the Act shall render the director or any other person responsible for the issue of prospectus liable to fine not less than 50,000 rupees, which may extend to 3 lakh rupees. In addition to this, the director or the official concerned may also incur civil or criminal liability for non-disclosure. However, in the event of omission to disclose the nature and extent of a director's or promoter's interest in the promotion of or property acquired or other person shall incur liability unless it is proved that he had knowledge of the matters not disclosed. The liability for violation of provisions of section 26 subsection 1 clause A of the Act will also be covered by section 34 and 35 of the Act. When prospectus need not be issued, the issue of a prospectus under section 26 of the Act is not necessary in the following circumstances, even though the shares are offered and application forms issued to the public by the company. A. Where a person is a bona fide invitee to enter into an underwriting agreement with regard to shares or debentures. B. Where shares or debentures are not offered to the public. C. Where the shares or debentures offered are in all respects uniform with the shares or debentures already issued and quoted at a recognized stock exchange. D. Where the shares or debentures are offered to the existing holders of shares or debentures respectively. E. According to section 30 of the Act, where a prospectus is published as a newspaper advertisement, it is not necessary to specify the contents of the memorandum or the names etc. of the signatories to the memorandum or the number of shares subscribed for by them. Section 27 subsection 7 Registration of Prospectus. According to section 27 subsection 7 of the Act, that no prospectus shall be issued by or on behalf of a company or in relation to an intended company unless on or before the date of publication there has been delivered to the registrar for registration a copy thereof signed by every person who is named therein as a director or proposed director of the company or by his agent authorized in writing. It must accompany the following documents: the consent of the expert if his report is to be published in the prospectus, a copy of every contract relating to the appointment or remuneration of managerial personnel, a copy of every material contract not being a contract entered into in the ordinary course of business of the company entered into within 2 years of the date of issue of prospectus, a written statement relating to the adjustments, if any, in respect of figures of any profits or losses and assets and liabilities, the consent in writing of the person, if any, named in the prospectus as auditor, legal advisor, attorney, solicitor, issue house, banker or broker of the company to act in that capacity. The consent of director in respect of new directors, if any, named therein. G. A copy of the underwriting agreement, if any, should also be filed along with the prospectus. Section 27, subsection 2, Registration on variation of terms in prospectus. A company shall not at any time vary the terms of a contract referred to in the prospectus or statement in lieu of prospectus except with the approval of the general meeting by way of special resolution, provided that the company shall not use any amount raised by it through prospectus for buying, trading or otherwise dealing in equity shares of any other listed company. The dissenting shareholders who have not agreed to proposal to vary the terms of the contract or objects referred to in the prospectus shall be given exit offer by promoters or controlling shareholders at such exit price and in such manner and conditions as may be specified by SEBI by making regulations in this behalf. Section 28. offer of sale of shares of certain members, where certain members of a company, in consultation with the board of directors and in accordance with applicable law, propose to offer the whole or part of their holding of shares to the public, they may do so in accordance with the prescribed procedure. Any document by which the offer of sale of shares to the public is made is to be deemed a prospectus issued by the company, and therefore all requirements as to contents of prospectus and liability for misstatements and omissions become applicable. The members, whether individual or bodies corporate or both, whose shares are proposed to be offered to the public, have collectively authorized the company to take all actions on their behalf for carrying out the transaction. They also have to reimburse the company for all expenses made by it on this matter. Section 29. Public offer of securities to be in dematerialized form. Every company making a public offer and such other class or classes of companies as may be prescribed have to issue their securities only in dematerialized form by complying with the provisions of Depositories Act 1996 and regulations made under it. Any other company may convert its securities into dematerialized form or issue its securities in physical form. Section 30. Advertisement of prospectus. Where an advertisement of a company's prospectus is published in any manner, it is necessary to specify in it the contents of company's memorandum as regards the objects, liability of members and the amount of the company's share capital, the names of signatories to the memorandum and the number of shares subscribed by them and its capital structure. Remedies for misrepresentation. Damages for deceit under law of torts. Deceit is a tort. It means fraud. The company is liable to pay damages to anyone who purchased shares on the basis of prospectus. In Derry v. Peek, 1889, Law Reports 5, Appeal Cases, the prospectus of a company stated that the company had been authorized to use steam power in moving its trams. A special act incorporating a tramway company provided that carriages might be moved by animal power and with the consent of the Board of Trade by steam power. So, the authority was in fact subject to the approval of the Board of Trade, which refused its approval. No reference was made to the Board of Trade, who refused their consent. Consequently, the company had to be wound up. The plaintiff, having taken shares on the faith of the statement, brought an action of deceit against the directors. Yet, the directors were held to be not guilty of fraud because they were honest, whereas fraud requires a statement which the maker knows to be false or does not believe it to be true or is too reckless as to its truth. The statement was certainly untrue because the power to use steam was stated to be an absolute right, when in truth it was conditional on the approval of the Board of Trade. But the directors honestly believed that once the Act of Parliament had authorized the use of steam, the consent of the Board of Trade was practically concluded. 2. The decision of the House of Lords in Derry v. Peek, 1889, 14, Appeal Cases, page 337, exposed the inadequacy of the tort action of deceit to protect the interest of investors in public companies. The investors' loss is just the same whether the misrepresentation is innocent or fraudulent. Accordingly, within a year of the decision in Derry v. Peek, the Directors' Liability Act 1890 was passed and the directors were made answerable for false statements, although they might have believed their assertions to be substantially true. The provisions of this Act have been reenacted in Section 43 of the English Companies Act 1948. Section 62 is the corresponding section in the Companies Act 1956. Section 35 of the Companies Act 2013 is the corresponding section to Section 62 of the old Act. Dear viewers, in this lesson, we discussed about prospectus, rules relating to issue of prospectus and remedies for misrepresentation in prospectus. I hope you enjoyed this session and we will meet in the next session. Thank you.